I'm Tony Scirica. I'm a judge on the Third Circuit in Philadelphia. I'm going to be the moderator for this part dealing with punitive damages. I have two distinguished participants with me today. Tom Gottschalk is the Senior Vice President and General Counsel of General Motors. Before that time, he was a partner and member of the Management Committee of Kirkland & Ellis here in Washington. He has been involved in all of the important General Motors cases over the past 2 decades. He received a law degree from the University of Chicago, and he will give us an interesting perspective on this issue. Dave Weiner is a partner in the Cleveland law firm of Hahn, Loeser & Parks, where he is also chairman of the firm. A graduate of Georgetown Law Center, he clerked for Judge Prettyman here in the D.C. Circuit. He has been a very active litigator nationwide and has chaired many committees, including the ABA litigation section. Both of these gentlemen are going to make a presentation. They will have some rebuttal time, and then we will open this matter up for your questions. Before we do that, I want to give a little overview of the punitive damage situation. Punitive damages are a powerful weapon and are ripe for reevaluation. These words were spoken by Justice O'Connor in her dissent in Pacific Mutual Life Insurance v. Haslip in 1991. Citing the past, she said that punitive awards had received scant attention because they were rarely assessed and were likely to be small in amount. They arose from a time when compensatory damages were not available for pain and suffering and other forms of intangible injury. Of course, time has changed all of that. Recent years have witnessed an explosion in the frequency and size of punitive damage awards, especially with respect to products liability and mass tort actions and even bad faith contract actions. Citing the arbitrary nature of punitive damage awards, Justice O'Connor said, due process requires the imposition of certain standards. Of course, there is another point of view, an opposing view, one articulated most clearly by Justice Scalia in his dissents in Haslip, in TXO, and most recently in BMW versus Gore. Calling the court's decision in BMW an unjustified incursion into the province of state governments, Justice Scalia said that a state trial procedure that permits judicial review of punitive damages for reasonableness provides all of the process that is due in this area. In other words, for punitive damages, a defendant is entitled to procedural due process, but not substantive due process. The 14th Amendment, said Justice Scalia, does not provide substantive guarantees against unfairness. He had another complaint about the majority's decision in BMW. He said the court did not really provide any real guidance as to what was constitutionally or unconstitutionally proper. Acknowledging that there were problems in this area, Justice Scalia said, it is up to the legislatures or to the Congress or to the state Supreme Courts to make these changes. We have heard a lot about BMW versus Gore in the last 2 days. It was a 5-4 decision. But what exactly did the Supreme Court say? Well, they said that the Due Process Clause of the 14th Amendment prohibits a state from imposing a grossly excessive punishment on a tortfeasor. When the award becomes grossly excessive, it enters a zone of arbitrariness. If you recall, the facts in the case are as follows. Dr. Gore had purchased a BMW for $40,000. Sometime en route to Alabama, it had suffered some paint damage. The repairs of repainting cost $600. There was testimony at trial that the car's value was reduced by about $4,000 because of the repainting. The jury awarded $4,000 in compensatory damages and $4 million in punitive damages, which was later cut to $2 million by the Alabama Supreme Court. The Alabama jury had decided that BMW's failure to disclose that a car had been repainted was a suppression of a material fact that constituted fraud. BMW had followed a policy of not disclosing repairs to new cars when the cost amounted to less than 3% of the car's value. This non-disclosure policy was consistent with the laws of 25 states defining disclosure obligations for auto dealers. As a consequence, there really was a patchwork of rules representing diverse policy judgments around the various 50 states. Because a justification for the award was to induce BMW to change its nationwide policy with respect to the disclosure of minor repairs, the court, citing principles of state sovereignty and comity, said that a state may not impose economic sanctions on its tortfeasors with the intent to change lawful conduct of tortfeasors in other states. And then, citing elementary notions of fairness, requiring adequate notice of the possible severity of penalties, the court set forth 3 guideposts to evaluate whether or not the award was constitutional. The first was the degree of reprehensibility. The second was the ratio or disparity between harm and the punitive award. And the third were sanctions for comparable misconduct. The court made clear that the most important factor was the degree of reprehensibility and said that trickery and deceit obviously are more reprehensible than negligence, and that repeated conduct was more significant than just 1 or 2 isolated instances. When they looked at the BMW case, the court said that none of the aggravating factors that are normally associated with reprehensible conduct were present here. They said, here we had purely economic harm. There was no reckless disregard of public health or safety. There was no bad faith. There probably was not even a material misrepresentation. And in fact, BMW probably was justified in relying on a safe harbor concept because many states had adopted similar policies. The court then distinguished the 2 most recent cases before BMW. Haslip, decided in 1991, and TXO, decided in 1993. They said in Haslip it was different because there were deliberate false statements. And in TXO, which actually had a ratio of harm to punitive damages very similar to this case, they said it was different because there were acts of affirmative misconduct, there was concealment of evidence, and there was improper motive. With respect to the reasonable relationship, you may recall in Haslip there was a 4 times ratio. TXO was much higher. In BMW, it was a ratio of 500 to 1. And the court said, in a nice turn of phrase, when the ratio is a breathtaking 500 to 1, the award must surely raise a suspicious judicial eyebrow. When the court looked at sanctions for comparable misconduct, they found that many states had rather minor penalties for these kinds of transgressions, and that Alabama in particular, under their deceptive trade practices law, had a maximum penalty of $2,000. And then at the end of the opinion, where they reiterated the federal interest in preventing individual states from imposing undue burdens on interstate commerce, the court said, look, we're still not applying a bright line rule. We're going to have to look at these cases individually. Interestingly, there was a concurring opinion by Justice Breyer that was joined in by Justice O'Connor and Souter. The concurring opinion, in a candid acknowledgement, said, look, the facts, the procedures in this case were not really very different from what we have already examined in Haslip and TXO. And in those cases, we said the procedures were perfectly fine, at least on a constitutional basis. And they reiterated the principle that if fair procedures are followed, there is a strong presumption of the validity of a punitive damage award. They said the presumption was overcome in this case for 2 reasons. 1, that Alabama's standards did not sufficiently constrain the jury's and the court's discretion. And 2, because the award was grossly excessive. They admitted that severe disproportionality reflects judgments about matters of degree, but said, in this case, it's easy to say that this award crossed the line. And so I think we're left with a situation where the Gore v. BMW case has breached the wall that heretofore has insulated punitive damages from constitutional review, but it probably hasn't breached it all that much. The cases, when you look at Haslip and TXO, the cases seem to say that if the ratio between actual and punitive damages is extremely high, and if there is no bad motive, if public health or safety is not involved, no deceitful conduct, then your award is probably in trouble on a constitutional basis. But absent that, it probably is going to stand. Of course, there are many legislative solutions that have been proposed both in the state legislatures and in the Congress, some of which have been adopted throughout the country dealing with caps, and our speakers will speak about that. At this point, I'm going to call on Tom Gottschalk.
I'm not going to spend time in my opening remarks talking about the nuances of Supreme Court decisions. If I did, it would become clear that I'm not a constitutional scholar and others are better apt to do that, but rather than get into a discussion of either the cases or some of the fine tuning that's been attempted through legislative compromise about punitive damages, I'd like to approach it a bit more from a policy perspective. And in thinking about what the style of that approach ought to be, I come out of a conference last Friday in Detroit that I attended that decried the decline in values and ethical standards that afflicts the legal profession and erodes public confidence in the American legal system. Justice Boyle of the Michigan Supreme Court at that conference observed at one point that she really wished that lawyers as advocates before her could figure out how to more dispassionately and objectively identify the weaknesses in their own arguments while they were so vigorously attacking their opponents' arguments just in the interest of candor and justice. And we recognize the difficulty in our adversary system of doing that, but I thought that I would propose to my colleague here, David, that we try that approach of civility on the panel. And so I will not approach this subject with my usual passion and vitriol and hyperbole when I think about punitive damages. Although, Judge, as soon as you mentioned BMW versus Gore and the facts of that case, I begin to feel the blood surge a little bit.
I hope that you would.
And I will say, in case I forget to mention it later, if anybody wonders about the effect of punitive damages on settlements, right after I came to GM and the BMW Gore case had been decided, and I was aware that the same plaintiff's lawyer had found plaintiffs to sue every auto manufacturer in similar theories. And I said, how could they possibly sue GM? What did we do? We don't import our cars and repaint them if they're scratched up in shipping. And the theory was that if in our quality inspection at a plant, we detected that there was any substandard paint aspect on that car, we would put it through a repaint facility at the very assembly plant where it was put together before we sold it, before we released it to the customer. And we were being sued for punitive damages for a flagrant disregard of consumer rights by not disclosing that fact that our quality standards had spotted something on a car before it was released for sale and we fixed it. And did we pay more in settlement for those cases than we might have because of the state of law in Alabama and the threat of punitive damages and the then state of the BMW Gore case without disclosing the amount? You bet we did. So a good practical example of the negative impact of punitive damages. But you can tell the blood's beginning to boil a little bit, and I'd like to turn back to sweetness and reason and all. So perhaps, David, you and I can reach consensus by the end of this. And how could this be done? I was thinking before getting my mind off on the Gore case that maybe the way to approach this is a clean slate approach. And let's assume David's the legislator and he's coming to the state legislature or the federal Congress to propose that we enact punitive damages. And we all have to sit down and consider whether that's good from a public policy standpoint or not. And the Weiner bill, as I understand it, is to allow the award of punitive damages, particularly in tort cases, according to criteria not defined in the statute, but largely to be developed through the judiciary through case law. So now we're going to sit down in committee and we're going to debate the merits of the Weiner bill for punitive damages. And I would think the starting point is to look at the context in which this proposal would be considered, assuming again that we do not have punitive damages today. And I think we'd have to acknowledge that the public interest in health and safety is currently protected by three major forces in our society. First and foremost, the marketplace. And I simply raise as a question that whether anyone in this room thinks that J&J consciously or even recklessly, if it consciously or even recklessly contaminated its Tylenol with poison, that we would still be buying any J&J products today, or that their executives would be walking the streets free. The fact that we see in J&J's conduct and other companies' conduct very moral and socially responsible responses to situations that arise regarding their products to address legitimate concerns about their safety is pretty strong evidence that business is motivated to adopt pro-consumer ethical behavior simply as a matter of good business to generate customer enthusiasm and commercial success. And if we really thought businesses were going to disregard those interests, they wouldn't be in business very long. Second, as part of the context in which we consider David's bill, we are a regulated society, regulated especially in the areas of consumer product safety and the environment through the Consumer Product Safety Commission, Food and Drug Administration, National Highway Traffic Safety Administration, EPA, and on and on. And don't forget the 50 state attorney generals and all the agencies at the state and local levels that also are dedicated to looking out and protecting the public interest. Certainly criminal sanctions, civil penalties, recalls, restitution, many other remedies abound to make sure that society punishes a wrongdoer, even a merely negligent tortfeasor, and assures that he does not profit from his carelessness, much less any intentional infliction of harm. The third mechanism in our society serves the purely private interest, and that is our litigation system, and you've been talking about the last day and a half. Unlike merry old England, the access to our judiciary by any actual or allegedly injured party is essentially unfettered. Indeed, we have class actions that permit the aggregation of claims by all similarly situated so they consolidate their resources and their leverage in a mass lawsuit. Individual redress for non-economic damages such as pain and suffering, as well as economic losses, is a cheap commodity in our current society, especially in the contingent fee world of product liability. It costs nothing to try and fail. In this setting then of a very competitive marketplace where the media quickly spreads the word, true or false, of any potential threat to consumer health or safety, a highly regulated marketplace in which the government actively seeks out not only to protect but to define the public interest, and a litigation system in which no injured party is prevented from making a toll-free 800 call, obtaining a free consultation, and securing effective representation from a lawyer for the promise of splitting the proceeds almost 50-50. In this context, David, what value will your bill add to society by setting up a system of punitive damages? Well, let's look at that system that you're proposing in the bill. It would allow for the lawyer for the injured party to include a claim for punitive damage whenever he or she, on their own, thought there was any chance of persuading a jury that the defendant's conduct should not go unpunished. This bill would put no limitation on what the lawyer could argue for in terms of the amount of punitive damages. It would simply create a further economic incentive for the lawyer to advance arguments about the defendant's misconduct by allowing the lawyer to retain a third or more of the punitive damages awarded. His bill would also allow the lawyer a broad choice of venue to pick localities in which local predispositions, if not outright prejudices, would tilt the scales of justice strongly in the plaintiff's favor. He would permit the lawyers to strike from the jury those individuals with the skills and temperament to base their decisions solely on the evidence they hear in court. He would encourage the lawyers for the plaintiff to turn every trial into a morality play, in which the defense counsel themselves are made to appear as co-conspirators if they try with the professional zeal expected of them to present an effective defense. He would allow the jury to consider such things as the defendant's net worth in deciding what amount to be awarded. He would ask them to consider whether the defendant had essentially confessed and shown contrition by conducting a product recall for a product that the defendant thought was safe. And if no recall had occurred, to sit in judgment, clearly substituting the judgment of a 6-person jury in some locality for that of NHTSA or the FDA or the EPA as to whether the product was safe or not. And as a topper, it would require the defendant to defend its conduct time and time again, since each plaintiff would be allowed a grab at the brass ring. And even if one jury awarded punitive damages, he would subject that defendant to the risk of even additional awards in other cases. So that's his proposal, and I look at that and say, well, it sounds awfully good for the plaintiff's bar, and maybe for their clients, but apart from that, is anybody else benefited, or are there some downsides? Well, clearly there are some major negatives. More and more we are learning in science and engineering that few, if any, blessings are entirely unmixed. There are trade-offs. Medications beneficial to millions may be harmful to a few, which testing may or may not uncover, especially if the harm is associated with excessive dosages or is the byproduct of interactions with other drugs or alcohol. Airbags in my industry are a classic trade-off. They save about 1,500 lives a year, but we may lose 2 or 3 small children a year because of the way they are installed in cars and we are required to install them in cars. Now, you may argue that it's morally superior to save a few innocent children's lives at the cost of 1,500 lives of adults too irresponsible to wear their seatbelts, and I may happen to agree with you. But surely the use of airbags mandated by federal regulation is not even a tort, much less the type of misconduct which punitive damages are intended to reach. We are being sued in no airbag cases for punitive damages and in airbag cases for punitive damages. There's no question that where trade-offs are inevitable, which is much of the time, and there is a residuum of new or altered risk, punitive damages inhibit and may totally discourage the introduction of innovations beneficial to the vast majority of the population or cause their removal. If punitive damages are not the equivalent of capital punishment, they are a weapon, as the judge said in his introduction, and the metaphor of a terrorist bomb may be more apt. So if punitive damages deter desirable conduct at the margin, wouldn't they deter some vestigial misconduct, which the marketplace, government, or the tort system might otherwise allow to escape? Well, let's look at the free markets of Europe and Canada and the 4 or 5 states that don't have punitive damages. And Europe's a good place to start, where they don't have punitive damages. Do you think the products made in Europe are any less safe than those that are made in the US? I don't think so. And somehow or other, their system functions just fine without the concept of punitive damages in terms of the protection of health and safety. In Canada, we now have about 100 product liability lawsuits, 2 of which make claims for exemplary or punitive damages. They've never been awarded. One of those has been dismissed. In 50% of the cases, and we get about 1,000 to 1,500 cases a year just in products, over half of them, or about half of them, contain a claim for punitive damages. There are other negatives simply from the fact that those cases are filed. The costs of settlement are driven up. I mentioned the Gore case by the threat of punitive damages, juries sitting in these pro-plaintiff venues. And if you get a large award, as we did recently in Alabama, that does have its wave effect and ramifications in other jurisdictions. So there are some real negatives, and I look then and ask whether the Weiner bill, since it's not really going to deter any misconduct that isn't already being deterred, as we see in Europe and Canada, and it does have these negatives, perhaps there are some other problems with it. What about its constitutionality? And as judges outlined the points there well from the Supreme Court, and while maybe substantive due process is not available as an argument, at least at the federal constitutional level under the current court, certainly the Commerce Clause and considerations of federalism should make us pause before we enact the Weiner bill. Juries should not, as a matter of due process, Commerce Clause, or federalism, be allowed to declare the sale of products as flagrant disregard for safety, where other jurisdictions, including federal agencies, regard them as safe. Nor under the Commerce Clause should one state be able to regulate products shipped throughout the 50 states to punish conduct outside its borders as reckless, which other jurisdictions may regard as reasonable and benign. In short, punitive damages are an anachronism. They are harmful to our society. They produce no meaningful deterrence. They bring the legal system, not to mention the legal profession, into greater disrespect in the minds of much of the public who are aghast at the cost and randomness of these awards. The costs are borne by all members of the public, whether in the form of higher product costs or the unavailability of new products. You like David's bill only if you are a plaintiff's lawyer or a potential litigant as a plaintiff. Do we really favor a system where a jury of 6 people anywhere in one of several forms can sit in judgment of these technological issues and related business conduct, wrenched out of context at the urging of a plaintiff's lawyer whose perspective extends no farther than his client's in his own pocketbook, and which often defies or is contrary to federal regulators' judgments, which are far more sensitive? Now, notwithstanding my objective analysis of your bill, David, I understand that it's going to the floor of the legislature, and indeed the votes are in. And not surprisingly, the legislature, which is populated mostly by members of the American Trial Lawyers Association, has passed it, leaving us in the fix we're in today. Too bad.
We'll ask Senator Weiner to respond.
Thank you, Your Honor. I'm delighted to be here, as usual, with these type. And Tom, I'm glad you don't get excited about this. No. God forbid. If you really took a partisan stand, we'd be in trouble. And of course, like this type of legislation, you only see it the last minute when it goes in the hopper. And I haven't had a chance to see that, but I'll get a chance to comment. I guess if that happened, God forbid, there'd be no need for any of us lawyers. But I don't think we have to worry. It's not a perfect world. Some people, some companies do break laws. Probably GM's not in that category. Some people commit torts. Some people engage in truly egregious conduct. And over the 200 plus years of our country, the jury's been the conscience of our community, and they've been able to vent their conscience when that truly egregious conduct does take place. We've lived with punitive damages for all these years. Yeah, they're on the rise. I'll talk about how much they're on the rise in a minute. We're probably going to live with them in the future. And I think what we need to do is, like good lawyers that we all are, is identify the facts and figures, get those in mind, and then reason together and figure out what's wrong with what's going on today, and then try to figure out a better way to do it. And the better way to do it would not be the Weiner bill. That's not what I'm espousing. But let's take a quick look at the facts and figures. And I'll try to do this really rapidly. You can tell I talk fast. I'm going to try to talk real fast. I thank Professor Rustad out and wrote in the University of Iowa Law Review on some of this a few years ago. And if you want all the details, look that up. First of all, there's a myth that they're really skyrocketing. The amount of punitive damages are skyrocketing. Well, there's a 25-year study that shows that there are only 353 product cases between 1965 and 1990. 91 of those were asbestos. There were only 270 medical malpractice cases. Half of all those were reduced or reversed on appeal. The average award was only $625,000. It got down to $135 on appeal. Obviously, this is an eye drop in all the civil litigations going on in this country. Most of the cases are actually in business contract and business tort cases. There's a RAND study that shows that 80% of all punitive damage cases are all in those two categories: business contract cases and intentional tort cases. What the public hears about and why there's so much uproar is the McDonald's coffee spill, the BMW, Exxon Valdez, and now I guess the Kmart potato chip case. I mean, that's the one of this week, and I assume you saw it. They also heard a lot about asbestos and the reorganizations that took place about that. I think there's some people that say there are campaigns to scare the public about punitive damages by talking about these cases. My guess is if there were really that many punitive damage cases, the big ones, the ones that hit the McDonald's, the Exxon, et cetera, wouldn't be news. No one would ever talk about it. When's the last time you've heard anybody talk about a $3 million lottery award winner? You don't hear about it anymore because it's not news anymore. These big punitive damage awards are out of the mainstream. They don't happen all the time, and they were not skyrocketing. The next myth is that punitive damages are awarded in extremely high awards that boggle the mind. That's a phrase you see time and time again. Well, if you use the mean, the average does get blown out, and it does look like a very large amount for all these punitive damage awards. But if you use the median amount, it shows that they're really quite modest. If you adjust it for inflation and you take into factors like growth in real income and life expectancy, you find that there's been no great increase. Third myth, and there's 9 of these: out-of-court juries award punitive damages that are many times higher than actual damages. I think most of us probably would have thought that. If you look at the empirical data on this, you find it's really pretty close on average. The ratio is 1.67 to 1. That's not out of whack. Yeah, there are some way out of whack. BMW, Supreme Court slapped that one down. But for the most part, they're pretty close to the amount of compensatory damages. There's a recent study done for Chicago Tort Reform Conference. You'll find that in that study that shows many cases over a long period of time, a very high correlation between actual damages and punitive damages. Fourth myth: judges are not controlling the runaway punitive damage awards. That's not true. All state punitive damage awards over this long period of time were upheld in less than 2% of the cases. It's between 65 and 90, forgetting about the asbestos. 4 out of 10 settled, 1/4 were affirmed, 1/3 were reversed or remanded. True in the federal court. Very few punitive damage awards in the federal court. Most of them, great majority, are reversed somewhere along the line. The judges have the tools. You know what the tools are. They have all these different steps to take care of the really wrong ones, and they're done in the vast majority of the cases. Fifth myth: plaintiffs are becoming instant millionaires by entering so-called punitive damage lottery. Well, that's not the case. BMW plaintiff didn't get $1 million. The McDonald's coffee spill plaintiff didn't get $1 million, reduced way back by the trial judge, ultimately settled far less than that. BMW, who knows what that'll happen. But it's the media that brings these to our attention. When they're reduced on appeal or when they're settled later on, very little media attention, if at all. And yet the big awards are what makes the news. There's no trend over any period of time that punitive damage awards are increasing by any huge amount, except in very isolated cases you heard about this morning. GAO study supports that, and the facts are very hard on that. Myth 6: the punitive damage awards in product cases are not the result of serious injury. They're really the result of a litigious society. That's not true. Almost all punitive damage awards in product cases, the plaintiff has been seriously harmed. There's a high degree of correlation between a catastrophic injury and the amount of punitive damages, just not a result of a sue-happy population. Myth 7, that the corporations are victimized by blameworthy plaintiffs. The opposite's true. You find that plaintiffs are victimized by blameworthy corporations. When the corporations are hit with punitive damages, in almost all the cases, some exceptions, no doubt about it, and we'll talk about those, you don't find it by negligent conduct. You find very high, egregious, outrageous conduct. You find 5 general themes of why they're hit in these kind of cases. Fraudulent type conduct, hiding data and not disclosing to the public, knowing violations of safety standards but not telling anybody about it. A lot of drug cases in that area. Inadequate testing and quality control during manufacturing, a rush to the market, get a product out without really doing the testing, failure to warn of knowledge. We have all these asbestos cases. They knew about asbestos in the 30s and the 40s and let it kept being sold, didn't take it off the market, didn't warn people, and sure, they got hit with punitive damage awards. I think everybody would want that to happen. Maybe not everybody. Post-marketing failures to remedy known defects, damages, a lot of things are on the market. People found out later on that they're not what they thought they were, but people don't redesign, don't recall, don't reduce the risk of known harm. Overriding theme in those product cases where corporations are defendants, a failure to take available safety steps once their known harm is in existence. Most of the punitive damages awards are just as likely to be in individual versus individual cases as they are individuals against corporations. Roscoe Pound study found recently that the overwhelming majority of American corporations, manufacturing corporations, have had no punitive damage awards against them in the last 25 years. 8th, the government sufficiently protects consumers by punishing corporate misconduct. I think the facts are clear. The government's both a slow starter and a slow finisher in this. They don't have the resources to do it. Often the government only gets involved after there have been a lot of court cases. Most of the conduct that is in light of the punitive damages are such that there are really no criminal fines. If there are criminal fines, they're too little to get the attention to make the changes. Some would argue that agencies and corporations are too cozy. I think the more reasoned view is that the government just doesn't have the resources to find out about this. This isn't their charge and they don't do the job. 9th and last myth, that punitive damages are a self-inflicted wound on U.S. competitiveness. No evidence, empirical evidence that shows there's a correlation between punitive damage awards and the competitiveness of United States businesses. United States business is not on decline. You don't have to look any further than the Wall Street Journal. You look any further into the marketplace. Money's pouring into the American businesses faster rate than ever before. Our exports are up. American business is doing very well. Further, all foreign manufacturers are subject to the same punitive damage laws that United States manufacturers. People that sell foreign cars in this country, the Subarus, the ATVs, all those people have been hit with punitive damages in appropriate cases. They get the same level playing field that the American corporations do with respect to that. Would we sell more without punitive damages? No evidence to support that. In the long run, I think limiting punitive damages would not improve competitiveness. What improves competitiveness is improving products. All right, trying to get those facts out of the way. Do we get benefits out of punitive damages? I think everybody would say they do. Have products changed because of punitive damage awards? Clearly they have. Do they get the attention of the defendants? Do they get the attention of potential defendants? Yes, they do. Consumer Federation of America estimates that approximately 6,000 deaths and millions of injuries are prevented yearly because of previous awards. It doesn't take anything in consideration how much money is saved because of previous awards. Would a cap help? Would a cap be the answer to that? Well, if you lower the amount of deterrent, would punitive damages still be the effective tool they are to change products? I doubt it, because then you can calculate how much that risk is. You might make the decision, well, we'll run that risk because it's a smaller financial risk, and we'll put a product on the market that is a little questionable on safety. Would punitive damages allow us to avoid, if we change punitive damages and get rid of them, what would we have? We'd have more government regulation. And Tom's mentioned some of the government regulation. We'd have to have 5, 6, 7 times that much of government regulation to get to the area of where we are with punitive damages in this country. We've been founded on a free market system. Punitive damages are part of that. They do help get safer products to the market. They do deter future bad conduct, and they've been part of the world that we've lived in. Let me just run off a few quick examples. Thanks. We got warnings on Tylenol about the use of that with alcohol. We got faulty surgical ventilators that have been removed from the market. Ford transmissions that jumped in reverse. We got asbestos. We got crib headboards. We got Playtex tampons. We got football helmets, highly inflammable PJs, and Ford Pinto. All those things have been removed from the market or changed or drastically made better because of punitive damage awards. No doubt we're a safer country because of those changes in the products that have been subject to the legislation. We got reform going on. BMW, Judge told you about how that works. On the federal front, we've got both the House and the Senate passed bills in 1995 that would cap punitive damages. Some in the House would do it in all civil cases, the Senate only in product cases. The conference report came out only for product cases. The president vetoed it. My guess is when President Dole takes over and you have a Republican Congress, you're going to have more legislation and looked at, and it may all get adopted. Is it the right way to go? I don't know. The states are all looking at it. Look to the dissent in BMW and Justice Ginsburg dissent. You can look at all the state reform efforts that are going on. Some are considering caps. Colorado has a cap, same as actual Kansas. Lesser defendants' annual gross income are $5 million. They're looking about allocating punitives to state agencies, bifurcation of trials. In Ohio now, we have the judge making the decision of the amount of punitive damages. I think the way to look at this, not as the Weiner bill, but a really good bill that's out there, the Uniform Model Punitive Damage Act that was just enacted, was just adopted by the Uniform Commissioners this summer in their second meeting on this subject. Over many years, spending a lot of time on this. They have a very good bill out there the states could consider. It's well balanced. It has good things for the plaintiffs. It has good things for the defense side. It has discovery only of wealth, only after a prima facie case, only on clear and convincing standards, tough and specific standards for vicarious liability. The amount's got to be fair and reasonable, taking into consideration remedial measures, on and on. Very good things. Credit for multiple awards, good things like that. They decided not to have caps. They thought caps were too arbitrary. If you have a small cap and a large problem, it's not going to work. Everyone understands that. If you have a huge corporation who's got a risky product and they get hit only 2 times compensatory, it's not going to make a change. They did consider other kind of caps, maybe tied to the amount of the ill-gotten gain or the worth of the net worth of the wrongdoer. Look at that Uniform Act. I think it's a good way to go. End point. End point. Thank you, Jim.
Thank you very much.
No doubt.
Good. Tom, you've got 3 minutes.
All right. It's difficult to respond to that point by point. There's not enough time to try. So let me give you some general reactions. First, I'm in favor of abolition, but I'll certainly accept substantial improvement along the way. So perhaps we can talk about that off panel. When I hear people say, well, the studies are inconclusive, some studies, like one in California, showed that juries had awarded $1.6 billion in punitive damages in a 5-year period from 1990 to 94. So there is evidence that the awards are on the rise, and certainly they're included in most of the cases filed in the product liability area. When I hear the plaintiffs' bar saying, well, it's really not such a big problem because we haven't been that successful yet, they haven't been awarded or sustained that often, I just treat that as an expression of frustration because they still put the claim in 50% or more of their cases. Second, they talk about, well, only where the conduct is really flagrant, like where data is hid. I'll give you one brief example. Case in General Motors, where we again instituted some internal objectives to stretch ourselves and to improve crashworthiness by testing our cars at a higher and higher crash rate. We provide those in discovery. The argument is we should have told the buyer of the car that we had run these internal developmental tests and what the consequences were when they were crashed at 50 miles an hour, so they could have had that information at the time they made their purchase. Totally ridiculous in terms of the sort of information that a consumer could possibly digest or receive at the time of sale. That's the sort of argument you're hit with in terms of data being hid. With regard to product safety, if you knew the amount of regulation, particularly on cars and the medical field and so on and so forth, any idea of that, we are over-regulated, not under-regulated. There are dozens, if not hundreds, of regulations that protect the public interest. With regard to competitiveness, there are higher costs associated with punitive damages, no question, whether it's settlement, transactional costs, or otherwise. I regard the best argument for punitive damages is if you like trade barriers like Ross Perot, you should be in favor of our product liability punitive damage system in this country because it is a barrier to entry from some foreign firms coming into some of our markets and some products. And lastly, on product safety and the need for it, and this is, I'll take just 20 seconds on this because it's most important. Whether it's General Motors or the clients I represent at the law firm, I've never seen a client consciously consider the threat of punitive damages in terms of making an improvement or developing their product. That was driven by the marketplace. I've seen them consider whether or not certain products ought not to be put on the market because of concerns about, again, the trade-offs and the risks of being sued if the product is not 100% favorable for everybody, and how do you manage that? What goes on in corporations is that people are motivated by their own ethics primarily and certainly disciplined by the marketplace to want to put a good, safe, effective product in the hands of consumers, and that's how they compete. That's what drives improvement in the marketplace. Punitive damages cause businessmen to look at our system as sick, unfair, and exorbitant. And it is counterproductive, certainly from the standpoint of confidence in the legal system.
Good. Thank you, Tom. Dave?
Well, let me. It's hard to know where to begin on this. Let's take Tom at his word, and I have no doubt that General Motors spends an awful lot of time and energy and tries to do everything right to make sure that the products get out on the market and they're safe as can possibly be. General Motors, we'll give them that. And for one, I'm a defense lawyer and try cases for businesses, both on the plaintiff and defense side. But for businesses, I've never understood the crash-worthy case. I can't understand that. I'd defend that case, to the end of the world, because I don't think that makes any sense, and a lot of them don't. But the fact of the matter is, we've had a history in this country where not everyone has done everything possible to put safe products on the market. And when they found out those products are not safe, they haven't done the responsible business-like thing and say, we're going to pull all those products off, or we're going to warn people, or we're going to take them out of our schools and our homes and our businesses. They haven't done that. That's just not the case in America. I mean, people have rushed to the market with questionable products. They've kept products on the market where they know they have endangering the lives. And those are the cases we're talking where truly egregious conduct exists, and that's where punitive damages should fall in, and that's where they have a proper role. If General Motors can tell and tell to stand up in front of the jury, and they got the best lawyers in the world, and show the jury what they've done is the proper thing, they're not going to lose punitive damage awards in 99, 44, 100% of the cases. Yeah, they may get a runaway jury. Some judge is probably going to take care of that, and now it looks like the judge doesn't do his job, or she doesn't do his job, or the appellate court doesn't. The Supreme Court's going to take care of them, I think, in most cases. All right, now I admit, some lawyers put in punitive damage award claims where they have no justification for doing that. I have never tried a case, I've never handled a case where any responsible corporate defendant says, we're going to pay more because there is some silly ass punitive damage claim in this complaint. We know in our jurisdiction, punitive damages aren't awarded for silly ass cases. You don't get them. You don't get them at all. And we're not going to pay a dime more. And in fact, if you put into punitive damage case, we're going to make you go to the test on that because we're not going to pay any more. And that's the way to deal with really lousy punitive damage claims. It's not to pay them more, because that just encourages more people to file them. And I think most responsible businesses, and I'll bet you GM does this in most of their cases, they don't pay extra for lousy punitive damage claims. They know what the statistics are. They know how few times they're really actually awarded, and when they're awarded, how often or how few times they're actually paid. And they value that into the settlement equation when you're making your decision, not the fact that some runaway jury down in Alabama does it on a crazy case or two. Done.
Thank you very much, Dave. I want to thank both of our participants for extremely interesting views here this morning. Why don't we go to the questions now? Do we
I have a question sort of back to the basics. Assuming that the compensatory damages performs its function of restoring the plaintiff to the status quo ante, and indeed including whatever pain and suffering the plaintiff has suffered, then the function of punitive damages is deterrence. Two questions regarding that. One, if deterrence is the function, and if the plaintiff has been fully remunerated, then why should the punitive damages be paid to the plaintiff? Why should it not be paid, for example, to the state to fund monies that might be then available to plaintiffs who are injured by defendants that are judgment proof or that are not apprehended, or where the recovery for whatever reason is too little or zero? That's question number one. The second question is, deterrence, it seems to me, boils down to the problem that the defendant will get away with it. Again, either that he's not caught, or if he's caught, he's not sued, or if he's sued, he's hit with too little or zero recovery, wrongly hit with too little, zero recovery. If we look at the Supreme Court's criteria, they seem to me not to address that means by which proper deterrence remedies should be formulated. For example, the criteria of comparable recovery available in other types of actions, just seems to perpetuate whatever problem now exists. The criteria of a ratio, we don't even know what the proper ratio is. It sort of begs the question. And the criteria of the degree of reprehensibility, it seems to me to be somewhat backwards in the sense that the more reprehensible an act is, the less likely it is that a defendant is going to get away with it without there being litigation and without compensatory damages performing its useful function. So again, I don't want to be too long-winded about this, but the two questions are, why should punitives be paid to the plaintiff, and what about the deterrent function?
Let me start with that. There are several proposals right now to have the punitive damages paid into a state agency or some other department, state treasury perhaps, or have it earmarked for a specific purpose, and some states have done that. Whether it makes sense in terms of policy, let me ask the panelists what their views on it.
Well, I think it doesn't make sense, probably because you got to, in order to get a punitive damage award, and I'm again a defense attorney, you got to fight long and hard and scream and kick and do a lot of work. And my guess is you ought to probably award that money to the punitive plaintiff's lawyer, because they're the ones doing that work and not the state. I think it's a legitimate argument, and maybe half of it goes to the state or something like that. And there's at least a couple states, and you can find that in Justice Ginsburg's dissent, that they're toying with that idea.
This is a segue into the luncheon presentation by Judge Winter of, is the defense bar part of the problem? We do fight long and hard, but Georgia, in its tort reform, actually provides for the state to take something like 75% of the punitive damages award. And in the Mosley case, it was interesting to watch the dynamics of that. I think as a matter of policy and philosophy, yes, we're really talking about public interest. The government's better equipped to step in and protect the public interest in terms of all of the considerations. And so using it for governmental interest makes a lot of sense to me. And frankly, if the plaintiff's lawyer doesn't get the money, there's less incentive to bring the frivolous lawsuit or think harder about whether to bring such claims. So there is some benefit to that. But again, I just raised the question of whether there's a need for it, as you suggest, in light of all of the other deterrents, criminal and civil, that are available to our society.
Good. And as to the second part of the question, Dave?
Well, I would just say, I think that if I was trying a case and you had punitive damages and you look at the BMW case, the question of reprehensibility would lead you to find out what the defendant has done to change the practices. BMW, I think, did change their practices, and now telling people, no matter what the cost of the repair was, there was this repair to the paint. If they want to buy the car, fine. If they don't, that's fine too. So, I mean, I think that's a factor in that first element under the BMW decision. At least it would be if I was trying a case.
Good. Yes, go ahead.
There seems to be some, or at least a possibility of some common ground between you two.
There's about 4 inches here.
I'd like to make the following proposal and see whether you think that it would, that you could support it in theory, and whether or not you think that it would have any impact in practice. It's always seemed to me that punitive damages are really a wolf in sheep's clothing, i.e. they're really a criminal punishment, and they're clothed in the trappings of a civil trial. How would you feel about leaving punitive damages in place, no caps, no limit, but raising the burden of proof to proof beyond a reasonable doubt, like it is in most criminal trials?
I think that's an interesting proposal. I had not seen that before. Maybe someone else had, Tom, maybe, Your Honor. I think it's worth studying. I've always had a hard time between clear and convincing evidence and burden beyond a reasonable doubt. You don't know what's going on through these jurors' minds, but yeah, I think it's worth looking at. I haven't seen it before. Worth thinking about.
I think one of the elements of tort reform has been to raise the standard for punitive damages. So if we're going to keep them, it's an appropriate thing to do. But I think you have to address other elements of the problem. And again, until you really worked in one of these cases in one of these venues and recognize what a morality play it is, it's not clear to me that there's a big difference between reckless disregard of human health and safety and proof beyond a reasonable doubt of that a person was acting with disregard for consumer interests. The ability to play on anti-corporate attitudes particularly is so strong in some of these jurisdictions that as soon as you walk in there, in fact, in this Alabama case recently, we were advised by local counsel that we could expect an award in the magnitude that we were hit with. And they were right. And when we interviewed the jury afterward, they said, oh, we knew it was going to get reversed anyway, so we just picked that number and knew it would get headlines. So when in those jurisdictions, raises the question whether this ought to be handled by a 6-person jury, whether it's under a criminal standard or civil standard. I think there needs to be more attention by the judiciary of tight control over this, more like an English judge would do, or else let's get the legislature to really clamp down on it.
Yes.
My question is directed to Mr. Weiner. As a plaintiff's attorney, does the presence of a punitive damages claim have an impact on your settlement demand, if at all?
Yeah, I mean, I think legitimate, as I tried to say before, maybe not very articulately, I think a legitimate plaintiff and a legitimate plaintiff's lawyer with a legitimate punitive damage claim gets more in settlement. I think if it's a trumped up one that you can see that there's really no likelihood, no reasonable likelihood that you're going to get punitive damages. Now, I'm taking out the Alabama and these 2 counties and thing. I'm not talking about being down there where they're obviously getting homeward. I don't think you get anything for a claim that doesn't have merit once you look at the facts. And I mean, Tom settles these cases, so maybe he'll have a different view.
There's what we call a venue tax, to be quite honest, and certain elements of the country where clearly the settlements go up. But the problem is that to do the sort of defense that David suggested earlier, we hire the best defense counsel in the country that we can find to present. It's expensive, and it takes a lot of testing. It takes a lot of effort. And so when you look at that in terms of the nuisance value of the cases, these are no longer $25,000 nuisance value cases. To do a privilege log in one case recently cost us $150,000. That's just one small part of a case. So you're talking literally millions of dollars to do an adequate defense of these cases.
Yes, well,
Let me start off by mentioning that if we were serious about duplicating in principle some of the protections for defendants in the actual criminal realm, we'd have to do a whole lot more than raising the burden of proof beyond preponderance of the evidence. Criminal defendants are entitled by the Constitution not to be forum shopped against. There is very particular venue. And of course, they are entitled to some sort of determinate sentencing. Though we wish to deter murder, we do not leave it as 1 to n years, but actually provide a maximum sentence. But of course, that's just murder. The question that I wanted to get into had to do with Mr. Weiner's interesting and I thought quite effective recapitulation of the law review literature in defense of punitive damages. Professors Rustad and Koenig are kind of the centerpiece of that, and I have always been fascinated by their argument in that law article that punitive damages are in product cases are rational because they are mostly awarded on one of these 5 theories having to do with either you rushed the product to market too quickly, you didn't warn adequately, you weren't forthcoming enough with information once a controversy arose, and a couple of others. And those fascinated me because, of course, they include pretty much all of the theories on which lawyers ever sue on corporate conduct in product cases. And given the large amount of data produced in discovery, there are a few cases in which lawyers can't raise some question about one of those issues. But the wider thing that fascinated me is that it ties in so neatly with what I always call my sauce for the gander proposal, namely to eliminate the exceptional industry, which is not currently called upon to pay for any damages, although it constantly goes around injuring people by rushing its products to market too quickly, by not disclosing their weak points when it rushes them to market, and by not fully disclosing the weak points even after controversy develops about them. Not to keep you in suspense, but this is the litigation industry. And the litigation industry's level of exposure for damages for its harms to innocent people, we know pegged along at the very comfortable level of 0 compensatory plus 0 punitives for many years. And then Rule 11 came along in 1983 and bumped them up to the totally intolerable level of compensatory damages in cases where they had been really malfeasant, and 0 damages for the great majority of cases. And this was considered intolerably high amounts of liability. So the last round of reform basically provided, if I understand the analogy correctly, a Gilder-Radner memorial never mind provision, where if the opponent points out the pleading has no basis in fact, you have a safe harbor in which to withdraw it, which is very similar, I think, to a corporation being allowed to get away from all compensatory damage by recalling its product. a complete installation. Now, the question, and I really am leading up to a question, is assuming that for purposes of consistency, we would of course want the litigation industry to have the same level of damage exposure, which I assume in this case is unlimited punitive damages for all cases where a defendant might ask for it after prevailing. The question then is, are the procedural methods going to be the same? And in particular, will the litigation industry submit to extensive discovery of what it knew and when it knew it by waiving lawyer-client privilege, and in general, will they submit to the to all of the procedural burdens that the substantive defendant now does?
I think the answer is maybe. I don't know. I tell you, I got lost somewhere. I apologize.
Two short questions, one of fact and one of speculation. The fact question is, do you know of any jurisdiction where punitive damages have been awarded in a bench trial? I've always been curious about that. And second, this is a speculative question, what would be the effect of whenever punitive damages were pled, you had to impanel a 12-member jury instead of a 6-member jury?
I don't know the answer to the first question. Anybody know one of a bench trial? There.
They've been awarded in bench trials. Yeah. Arbitrations too, incidentally.
Yeah, well, that's true. Even in securities cases,
Yeah.
in arbitrations. Yeah. And the second thing, I don't know. I believe in the 12-person jury. I think 6-person juries are a wrong way to go, and I think they should be in all cases.
I'd rather have a court-appointed expert come in and advise the court as to whether this was really the sort of conduct that rose to the level of flagrancy and reckless disregard, particularly when any technical issue was involved, medical product or whatever, and have some threshold determination by the court before it went to any jury, 6 or 12-person.
How do you like that, Judge?
Good. The 12-person jury issue is now before the judicial conference. They're going to be considering it next week.
My question, about 12 months ago in England, they established something called the National Lottery, and the top prize was £25 million. And since then, the whole nation appears to have become a nation of gamblers. And what I want to ask is that in that context, do you consider that the ability to claim punitive damages in America effectively has a major contribution to play on the psychology of the nation, in the sense that they all think that they have the ability to suddenly become millionaires by bringing a piece of litigation? And I think that in terms of when does a society start to have concerns about itself, the story that I heard yesterday, I think, about the woman who claimed to have been a passenger on the bus that had been used in the trial accident is possibly the best story that I've heard.
Yeah,
I wonder.
that too.
Well, I do think the media is at fault. The McDonald's coffee spill, I think if you go back and research that and see how the media carried that, you think everyone in the United States should have gotten the position from the media that this lady, was driving her car with hot coffee in her lap and didn't know any, had a lot of experience with this coffee. And, the facts were nowhere near that. And the media never played up the remitter that the judge did, or the final settlement, which is non-disclosed to court. So I think that the media does have a problem there. And I think, but, that's the excitement. Media, it's no fun for the media to say, the McDonald's coffee spill case went from $2 million down to 40,000 or 400,000 or whatever it was.
My answer to your question is yes.
Yeah.
Good. Ladies and gentlemen, thank you very much. Thank the panelists here.